decision of operation policies, the employer had the power to dismiss the employee. This Honorable Court has also found in Policy 2A and B, Policy Code 5030 at page 44 of Exhibit D12, to the effect that serious misconduct includes dereliction of duty, breach of rules and regulation imposed, corruption, misappropriation of company's property, seeking or accepting bribe or other forms of gratification. It is not in doubt that reasons advanced by the defendant for the summary dismissal of, in this case, are weighty enough to fit into the class of serious or gross misconduct as it is. In no doubt that carrying out counter sales, which requires approval without approval, and carrying out counter sales with the claimant admitted, which the claimant admitted is part of the procurement department after being posted out of that department, drawing up invoices for company supplier, failure of the claimant as the last betting officer to cross-check the cost presented by costing officer before submitting it for management's final approval. All these indeed are conducts that are capable of undermining the confidence which would exist between the claimant and his master. The dependent and thus not only the prejudicial his master, the defendant, and thus not only prejudicial to the latter's interest, but also prejudicial to the discipline and proper administration of the dependent company, and thus reprehensible. Since misconduct is what the employer makes it out to be, and this Honorable Court having found justification in the above heads of reason advanced by the defendant, this court cannot hold that the summary dismissal is unlawful, illegal, unwarranted, or wrongful, as claimed by as prayed by the claimant. All these proved acts and omissions of the claimant are enough to indeed make an employer lose confidence and trust in the employee's duty. In all, I hereby hold and find that the summary dismissal of the claimant complied with the terms and conditions of the contract of employment between the claimant and the defendant, and the reasons advanced by the defendant have been justified and sufficiently enough to ground summary dismissal of the claimant, as the defendant has done in this case. I so hold reliefs A, B, and E of the claimants having failed are accordingly dismissed. I find and I so hold. Coming to the second issue, having held that the summary dismissal is neither unlawful nor wrongful, can this Honorable Court accede to reliefs C, Roman 1 and 2, and G of the claimant? It is tried law that where a dismissal of an employee from his employment is not wrongful, the employee is not entitled to damages. See the case of Ansambe against BON Limited and Ekunola and CBN. Ulejede and the mill admin Benue, military administrator of Benue State. Citations of light. Thus, the claim of the claimant in relief C, 3 and 4 fall under this category, which Honorable Court must critically examine and evaluate the evidence led to determine whether the claimant has established these objects of claim. This court has noted that it has pleaded and that it was pleaded and in evidence that the defendant owed the claimant 2 years annual leave allowances, and this was clearly admitted beyond any iota of doubt by the defendant, who only disputed the figure claimed by the claimant, and the claimant in return also conceded the figure admitted by the defendant. This Honorable Court does not see any reason not to incline to and grant the relief C3 and grant relief C3, but in the sum of 321,000 only admitted by the defendant and acceded to by the claimant in this case. The subhead 3 of relief C of the claimant is hereby granted as prayed. I so hold. With regards to subhead 4 of relief C, sales incentive, the claimant tendered Exhibit C12, C21, and C22, which respectively are sales incentive policies and sales documentation or record of the defendant. First, it is important to resolve the objection raised by the defendant against the admissibility of Exhibit C21, erroneously called Exhibit C22 by the defendant. This same was neither pleaded nor front-loaded by the claimant. That same was neither pleaded nor front-loaded by the claimant. This court has calmly gone through the response of the claimant on the grounds of objection. I also have looked at the claimant's reply to the statement of defense and noted at paragraph 13 thereof, as well as the front-loaded document. This honorable court cannot but agree with the claimant that the objection of the defendant in this regard is baseless, as the said document is not only pleaded in the above paragraph, but also front-loaded with the said reply to the statement of defense. The objection of the defendant is accordingly discountenanced and overruled. I hereby hold that Exhibit C21 is properly admitted in evidence in this case. The defendant's learned counsel has contended that Exhibit C21 has nothing to do with the claimant as the defendant, and thus irrelevant to this case, while the claimant contended otherwise, stating that Exhibit C21 was recorded by the defendant itself in the course of business and cannot deny its existence, and that it is not correct that it has no reference to the defendant and the claimant, being the record of sales made by the defendant and the amount with respect to same, duly recorded by the defendant. I have taken time to examine Exhibit C21, and I agree with the claimant that this piece of document is relevant in the determination of this issue of sales, sales incentive, as it is obviously the record made by the defendant with respect to the sales. I find and I so hold. Exhibit C12, that is the defendant sales incentive policy, the defendant contended on Exhibit C12, that is the defendant sales incentive policy. The defendant has contended that Exhibit C12, erroneously called C21, made general incentive provisions and its application is discretionary and not obligatory as the claimant alleged, and that the claimant did not prove how he arrived at the sum of 239,442 naira 65 kobo he claimed as the sales incentive from September 2015 to May 2015. The claimant referred to items 1 and 2 of Exhibit C12 to the effect that sales made under those items are entitled to the incentives commission as stipulated therein, and it is only sales under item 3 of Exhibit C12 which deals with discretionary commission applicable to this to sale of goods in different circumstances. Claimant posited that the sale in this case fall under item 1 and 2 of Exhibit C12, and the claimant is entitled to the incentives applicable thereto, which is 2.5% of the sales made by the claimant. Claimant made reference to Exhibit C21 and C22 to show the items sold by the claimant, to show that the items sold by the claimant and the amount recorded, to show the items sold by the claimant and the amount as recorded by the defendant. Carefully borrowed through Exhibit C12, C21, and C22, and found that in Exhibit C12, items 1 and 2 thereof provided for the incentives being claimed by the claimant in this case. Item three thereof is specifically for discretionary omission. For avoidance of doubt, it is pertinent to reproduce the said paragraph in this judgment. I will skip it. The above clauses are very clear as to the categories and types of incentives in item 1, 2, and 3. If the maker of Exhibit C12 new incentive scheme intended that same clause in item 3 should apply to item 1 and 2, they would have so specifically stated thus as they did in item 3. Having not stated that the incentives in item 1 and 2 are discretionary, but only that adjective in item 3 and further limit the discretionary commission of the maximum of 1%, which is clearly different from and smaller than the fixed incentive of 2.5% in item 2. This court cannot agree with the defendant that item 3 extended to item 2 and 1. This court finds that the three separate and distinct form. I find that the three are separate and distinct from one another. Each item provides for distinct incentive wherein item 1 and 2 are fixed and not expressed to be discretionary. Only item 3 is discretionary, I find, and I so hold. On the calculation of the earned incentive, I have noted in Exhibit C12 that the percentage is 2.5% as required by the claimant in Exhibit C21. This honorable court has also found that total sales made by the claimant in the total sum of 9,577,706 naira, 1 kobo, from September 2015 to May 2016. By simple arithmetic, the sum of 239,442 naira, 65 kobo claim in this case is the same product of 2.5% of this total sales made by the claimant. The claimant having earned this incentive before his dismissal, he is entitled to the claim sum which he has established by credible evidence before this honorable court. I find and I so hold. With respect to relief D, which had become spent and no more alive before this honorable court, it will amount to a mere academic exercise with no utility value for this honorable court to dwell on the said relief. The said relief is hereby struck out, having become odious, overtaken by event, redundant, and no more live issue. Finally, relief F on return of personal belongings of the claimant, while the claimant testified that he was not allowed to remove these items itemized at paragraph 14 of the claimant's statement on oath from his official car on the date of dismissal. The defendant denied being in possession of these items, and by the testimony of DW2 at paragraph 10 of the second defendant's witness statement on oath, testified that nothing of such was left behind by the claimant, and that the said vehicle is not the claimant's official car, but a workman's pickup vehicle assigned to the claimant, and it was not reasonable to expect an employee to keep his documents in that vehicle. Defendant also tendered the handing over email correspondence, that is Exhibit D9. The burden of proof remains on the claimant to establish by credible evidence that he indeed left those items in the said car. The defendant having denied this assertion, the claimant, who is the one that will lose if no further evidence is adduced, ought to have gone further and present further evidence to show that he indeed left those items in the said car. Now, in the absence of the evidence, These court cannot embark on speculation and guesswork to assume that these items were indeed left in the said car retrieved from the claimant by the defendant on the date of dismissal. I therefore hold that this claim is not proved by the claimant in this case, and same is hereby refused. In all, while the claims of the claimant fails as regards to relief A, B, C, 1 and 2, E, F, and G, the prayers of the claimant in items 3 and 4 of relief C are hereby granted to the following extent as contained hereunder. 1, that the defendant is by the order of this court directed to pay the claimant immediately the sum of 321,840 naira only, being the claimant's unpaid annual leave allowance for 2015 to 2016. 2, that the defendant is also by the order of the honorable court directed to immediately pay the claimant the sum of 239,442 naira 65 kobo, being the claimant's unpaid salaries, sales incentives for the claimant's unpaid sales incentives for the counter sales he made from September 2015 to May 2016. The above 2 orders made will attract 10% interest per annum upon the claimant, the defendant's failure to so pay the said amounts within 30 days from the date of this judgment. Judgment is entered accordingly. I make no order for cost.
As the court pleases.
As the court pleases, sir.
Thank you.
We thank the Lord for the very incisive judgment. We are grateful.
Thank you.
We're grateful for the wise judgment, sir.
You're welcome. The second case on the course list is suit number NICN/LA/229/2018 between Joy Afulenu Ugu and Keystone Bank Limited.
My Lord, Keystone Bank Limited is present. It's represented by Julius Idigbe.
Yes. What is his designation with the defendant? Who is representing the defendant?
My Lord, Julius Oyedeji.
What is his position?
He's HR manager.
Okay. Announce the claimant in court.
No,
the
sir.
Claimant present. Okay. Announce appearance, please.
May it please your lordship, my name is Peter Olomola. I appear for the claimant, sir. My learned colleague, Abiba Bankole Apina, appears with me.
Yes, who is
My
appearing for
Lord,
the
please.
yes?
I'm Adenike Kolawole. My Lord, I most humbly appear for the defendant. I'm most obliged, sir.
You're welcome. Counsel,
Sir,
all the remaining 4 judgments have certain things in common, particularly with respect to objections and preliminary objections in the defendant's final written address and the response made by the claimant. I will therefore save on the reliefs that are different. I will read this one, but when I come to read the subsequent ones, I will skip all those aspects where the cases share with each other. I hope you get, with one another. I hope you get me in order to save time.
Yes.
Mrs. Kolawole,
My Lord.
did you hear me?
Yes, I did, my Lord.
So do you concede?
Yes, I concede, my Lord.
Okay. In order to save time, because we don't need to be repeating ourselves. So the judgment is ready and I will read it. I will read the introduction and the reliefs and I will skip the submissions of counsel and read the decision portion. By general form of complaint, statement of facts, and other front-loaded documents dated and filed on the 11th of April 2018, the claimant approached this court claiming for the following reliefs against the defendant. 1, the sum of 7,323,527 naira 50 kobo, being the outstanding redundancy entitlement in line with the item 8.2 of the Dependents Capital Policies and Procedure Manual 2013 as amended in 2015. 2, the sum of 1,220,587 naira 92 kobo, being the claimant's entitlement in lieu of 1 month's notice, which the defendant did not give to the claimant. 3, the sum of 5,250,000 being the year 27th month car amortization allowance that was not paid to the claimant. 4, the sum of 139,000 being medical expenses incurred by the claimant, which sum the defendant failed to refund to the claimant. 5, interest and the sum of 1 over reliefs 1 to 4 above at the rate of 12% per annum from 1st January 2018 till judgment, and thereafter at the rate of 10% per annum until the final liquidation. 6, the sum of 750,000 naira being cost of litigation. The defendant filed memorandum of appearance and other defense processes. And later the defendant sought the leave of this court, which leave was granted, by which it amended a statement of defense and counterclaim against the claimant. Thus, A, a declaration that the defendant is entitled to a refund of the sum of 7,323,527 naira 50 kobo paid in error into the claimant's account as redundancy payment, 6 months salary in lieu of notice under the Human Capital Policies and Procedure Manual 2017, which policy the claimant has refused its applicability and has elected 1 month salary in lieu of notice under the terms of employment. B, declaration that the claimant is entitled to the sum of 1,220,587 naira 92 kobo, being 1 month salary in lieu of notice under the claimant's terms of employment. C, an order setting up the sum of 1,220,587 naira 92 kobo, being 1 month salary in lieu of notice against the defendant's 7,323,527 naira 50 kobo paid in euro into the claimant's account as redundancy payment, and an order directing the claimant to refund and credit the defendant immediately with the balance in the sum of 6,102,939 naira 58 kobo. D, an order for 21% for judgment interest per annum until final liquidation of the judgment sum of 6,102,939 naira 58 kobo. A reaction that claimant filed a reply to the amended statement of defense and defense to counterclaim on the 8th of January 2019. The defendant did not file any reply to the claimant defense to counterclaim. This suit proceeded at the close of pleadings upon the claimant's statement of facts filed on the 11th of April 2018. The defendant amended statement of defense and counterclaim filed on the 29th of October 2018, and the claimant replied thereto. Parts of the case. The claimant was employed by Legacy Habib Bank in 1990, which later metamorphosed into the defendant who appointed her as a manager on the 5th of August 2011 and was later promoted to the grade of senior manager on the 22nd of May 2014, in which capacity she served till the termination of her appointment on the 28th of December 2017 by a notice of cessation of employment, but that the sum paid to her as her entitlement fell short of the amount due to her under the Defendant's Human Capital Policies 2013, as amended in 2015, that the notice of cessation of employment read thus, and I quote, "In line with the terms of redundancy policy of the bank, your terminal benefits are stated below. 5 years and above in service to Keystone Bank, 6 months guaranteed pay, which is 6,195,171 naira 36 kobo. During trial, the claimant testified for herself and tendered 12 documents, which were admitted and marked as exhibits C1 to C12 respectively. It is the defendant's case that the claimant is not entitled to the sums claimed, that even the payment made to the claimant were made in error, because under the Defendant Human Capital Policy 2017, which was approved on the 20th of December 2017, a week before the claimant's employment was terminated and thus applicable to the claimant is only entitled to 1 month's payment in lieu of notice and nothing more. That the defendant, under the terms and conditions of service between the parties, has the unreserved right to amend its human capital policy and at any time, and that the claimant is bound by such amendments. That since redundancy does not exist under the Human Capital Policy 2017, the payment made by the defendant for the redundancy to the claimant was made in error, and as such, the claimant is only entitled to 1 month's salary in lieu of notice, that the defendant is therefore entitled to a refund of the balance of the redundancy sum paid to the claimant after deduction of the 1 month salary in lieu of notice, which the claimant is entitled to from the sum paid. The defendant, in defense of this action, testified through its officer and tendered 4 documents, which were admitted and marked as exhibits D1, D2, D3, and D4, respectively. I now move to the decision portion. I've carefully examined the processes filed, the evidence, and submissions of counsel for both parties. And I formulated the following issue for determination, sole issue for determination. Thus, and whether the claimant has proved her entitlement to the relief sought on the balance of probability and preponderance of evidence. Before determining the merit of the case, I will first and foremost determine the preliminary objection launched against this suit by the defendant, which is predicated on the ground of lack of locus standi and non-justiciability of the course of action advanced by the claimant. This, the defendant, situated in paragraph 7 of the statement of facts and paragraphs 2 and 3 of the claimant reply to amended statement of defense. It has been established in plethora of judicial decisions that a court has no jurisdiction to entertain a matter that is not justiciable, and no one has the locus standi to initiate a course of action that is not justiciable. See the case of Basinco Motors Limited and Woman Line and another. And Akat Nigeria Limited and another versus Unity Bank, citation supplied. In determining what the cause of action is in this case, it is tried that this court is only given the power to look at the originating processes and the pleadings of the claimant and not the defense of the defendant. The definition of a cause of action has been distilled in plethora of judicial authorities, too numerous to mention. Like in the case of Ibrahim and Osim, the Supreme Court held thus, and I quote, the word cause of action without the adjective reasonable had been defined by this court in Savage and others versus Witcher, where Patai Williams JSC, as he then was said, a cause of action is defined in Stroud Judicial Dictionary as the entire set of circumstances giving rise to an enforceable claim. To our mind, it is in effect a part of combination of parts which give rise to right to sue, and it consists of 2 elements: the wrongful act of the defendant, which gives the plaintiff his cause of complaint, and the consequent damage, as Lord Esher said in the case of Cook versus Gill, and later in Red versus Brown. It is every fact that it would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court. End of quote. See also the case of Yusuf and others versus Akindipi. Thus, from the foregoing, it is clear that a pleading will contain series of facts setting out the circumstances which the claimant averred to constitute his course of action. One of those parts standing alone may or may not on its own be enough to sustain a course of action. It is the aggregate of these parts put together that constitute the circumstance. In this case, I have looked at the abatement complaint by the defendant, which the defendant contended has constituted non-justiciable cause of action over which the claimant has no locus standi. The abatement complained about are simply some of the facts pleaded by the claimant in support of the course of action. Can we have silence, please? The grievance or course of action in this case, as can be garnered from the total reading and study of the statement of facts, is not that the defendant has no power or right to update, review, or alter its manual, but that the claimant is only bound by the defendant's manual in existence at the termination of the employment and not the one thereafter, and that by making the manual that came into existence after the disengagement to apply to the claimant was unjustly and unlawfully deprived of her entitlement under the previous manual, which is applicable to her. That is the complaint of the claimant. Flowing from the foregoing finding, I cannot but dismiss the preliminary objection of the defendant as being destructive, frivolous, and unmeritorious. I find and I so hold. I shall now go into the merit of the matter. It is not in dispute between the parties in this case that the terms and conditions of service of the claimant are as provided by the letter of offer of employment, coupled with the conditions of service provided in the dependent's policy manual. The point of divergence between the parties is which between the 2013 manual, amended 2015, that is Exhibit C4, and the 2017 manual approved by the Board of Directors of the Dependent on the 20th of December 2017, Exhibit D3 is applicable to the claimant whose employment was terminated on the 28th of December 2017. While the claimant contended that Exhibit C4 is the extent applicable manual at the point of termination, the dependent posited that it is Exhibit D3. The starting point is the common law position that once a right is vested in one party in a contractual situation, it cannot be taken away by the other party to the contract except with the consent of the beneficiary. I refer to the case of Score Nigeria PLC as Efezua and Ponix Associates Limited and another as Hercules Maritime Limited. Citation supplied. However, this principle admits of some exceptions, which includes where the provision of the contract empowers a party to unilaterally update, review, or alter a term or condition. The court is bound to honor the terms agreed between the parties in the absence of any vitiating factors. In the case of Eminite Limited and Oleka and Amodu, citation supplied. Both parties are in agreement in this case that the dependent reserves the right to review and update its policy manual. However, while the dependent contended that the review or update becomes effective the moment it is approved by the management of the dependent and need not be communicated to the plaintiff and to the claimant, and need not to be communicated to the staff and or the claimant before it becomes binding on the claimant. The claimant posited that the update or review will not come to pose to bind the claimant until the change is notified to the claimant. On the second leg, while the defendant asserted that the update or review of Exhibit D3 was communicated, published on the defendant HCM portal on the 20th of December 2017 to all staff, including the claimant, and was only further communicated on the corporate portal on the 29th of December 2017, when some employees complained that they were not aware of Exhibit D3. The claimant denied this assertion and posited that he was at work on the 20th of December all through to 28 December 2017, when she was put out of the dependents. She was shut out from the dependents HCM portal, which her job terminated, and there was nothing of such published or communicated on the HCM portal. That the same that she came about, which he came about Exhibit D3 about another through another sympathetic employee of the dependent, to the effect that the dependent published or communicated Exhibit D3 on its own corporate portal to all staff in the evening of the 29th of December 2017, which was after the cessation of her employment. Claimant tendered Exhibit C11 in evidence or proof of the publication. I totally agree with the defendant based on the evidence adduced before this honorable court as to the provision of Exhibit C4, as well as Exhibit D3, that the defendant reserves the right to unilaterally amend in its policy manual. However, this right cannot exist without the corresponding duty to notify the change to the other party. It is an obligation which the law implies. It will be repugnant to logic, common sense, equity, and law to approve of the line of argument that a party can unilaterally alter condition of service without communicating the change to the other party to allow the other party exercise his right whether to continue under the new condition or resign. This will tantamount to saying such a party can unilaterally alter the condition of service and keep it in its pocket, just to suddenly wake up in the future and waive it at the other unaware party to escape liability for its action or omission. And as such, an ambush. It does not only beat morality, but also the law. As such, this honorable court hereby holds that the unilateral amendment of Exhibit D3, Exhibit C4, Exhibit D3, C4/D3 will come into force upon notification of same to the staff concerned, or at least brought to the awareness of the staff concerned, and not when the dependent board of directors approved it. Communication is key and very fundamental to the coming into force of any unilaterally affected provision intended to be binding on another party. This is the case of Eliwidim and Oduma. Citation supply. Delivery and receipt of document are questions of fact which requires proof. See the decision of my learned brother, Iwane Kaji, delivered on the 19th of March 2021, in suit number NICN LA 597/2019 between Olawale Olorinshaw versus Fidelity Bank PLC, which this honorable court find very apposite and helpful in this instance. As a general principle, proof of delivery of document is by production of a dispatch book indicating receipt or evidence of dispatch by registered post, or evidence of a witness credible enough to prove that the person was served with the document. See the case of Nwidilim versus Unduma, Supra. Shoprite Checkers Property Limited and another versus AIC Limited. However, in the instant case, communication between the parties is by email and online portal. The claimant having denied the communication of 20th December 2017, alleged by the defendant to have been made on its HCM portal. The onus is on the defendant who asserted the positive to prove that assertion. See Section 136 of the Evidence Act 2011. I have thoroughly evaluated and reviewed the testimony of the defendant witness one, who admitted the publication of the 29th of December 2017, but also claimed that Exhibit D3 was approved by the board on the December 2017 and was published, and same was the publishing date of the on the HCM portal. The defendant ought to have gone further to present a printout of the proof of online publication to show and establish the date and time it was published or communicated or notified to staff on that HCM portal, and to back up the explicit assertion that it was so published or communicated. But in the instant case, the defendant did not. There is no reason advanced by the defendant for this failure. It is not in doubt that the defendant had the control of its HCM portal and the communication is in its custody. It is not in doubt that this evidence is vital and material on this issue. Who is making silence, please? Can we have silence? Who is speaking, please? Can you mute your device? Who is making noise? It is not in doubt that the defendant had the control of its HCM portal and the communication is in its custody. It is also not in doubt that this evidence is vital and material in this issue of communication or publication. On this issue of communication or publication, yet the defendant chose to withhold it and thus deprive the Honorable Court of the benefit of utilizing it to arrive at just and fair determination of this issue. Moreover, the defendant referred to Exhibit C11, which it earlier challenged for being undated, unsigned, and altered, and submitted that it is true that the document was notified on the 29th of December 2017 on the corporate portal, but that it only provided a link to the document from the corporate portal to the HCM portal, where it was already published since 20th December 2017. The defendant also referred to the effective date stated in Exhibit D3 itself to be 20th December 2017. All these arguments of the defendant cannot take the place of the positive and credible evidence of the publication or communication of Exhibit D3 to stop as required by the law to establish the date and time of the communication, and this Honorable Court cannot speculate on this yarning gap and missing link in the proof of the defendants, in the proof by the defendant. This is the case of Oduadu versus Haruna, Echenta Best, Nigeria Limited, and Attorney General of Rivers State. Awolola versus Governor of Ekiti State. Citations of light. The defendant also urged this court to take judicial notice and notice of adopt, accept, and act on the testimony given in another suit on the issue of communication or publication of Exhibit D3, since the case arose from similar facts and circumstances to this instant case. Meanwhile, the record of proceeding of that suit is not placed before this court, before this honorable court. Nevertheless, the defendant relied on the combined provisions of Section 46, 122, 232 and 237 of the Evidence Act 2011, which I reproduce here, but I will skip. It is tried that an address of counsel, no matter how beautifully and brilliantly marshaled, can never take the place of evidence. What ought to have been presented at the trial as evidence cannot be imported into the case in the final written address and be urged on the court to treat as evidence. I refer to the case of Idigbe and another versus Amosu, Nemi and others versus the state, BFI Group Corporation versus BPE, and Sadiq against Balarabi. This honorable court hereby decline the invitation and refuse the temptation to adopt, accept, and act on the said testimony of the proceeding conducted before my learned brother Basi G in a similar matter. The defendant's argument in this regard is hereby discountenanced, and I so hold. In contrast, the claimant asserted that Exhibit D3 was only communicated on the 29th of December 2017 and went further to tender Exhibit C11 as the email printout or screenshot as the proof of the publication. After a careful scrutiny of all the grounds of objection raised by the defendant against the admissibility as well as the evidential value of Exhibit C11, this honorable court find the admission by the defendant first witness on the part of the publication on the 29th of December 2017, which is copiously reiterated in the final written address of the defendant as positive, direct, credible confirmation of the proof of publication on the 29th of December 2017. As such, the grievance of the defendant is not about the fact that it communicated Exhibit D3 to all staff on the 29th of December 2017 as alleged by the claimant, but that Exhibit C11 is altered, undated, unsigned, and the rest. Having admitted that it communicated Exhibit D3 on the corporate portal to all staff on the 29th of December 2017 due to the complaint by some of the employees that they were not aware of Exhibit D3, though claimed to be the second publication by way of a link to the document on the HCM portal. All argument of the defendant tailored to deny this fact becomes obtuse, as the defendant cannot be allowed to approbate and reprobate on the same fact. See the case of Globe Motors Holdings Limited and Ibrahim Nona and GT Bank and others, Past Approach Construction Limited and Guarantee Trust Bank and others. Flowing from the foregoing finding, I hereby held that Exhibit D3 is abundantly established to have been communicated to the staff on the 29th of December 2017 and not on the 20th of December 2017. Consequently, I find and hold that Exhibit D3, being a unilateral amendment, became effective and came into force on the 29th of December 2017 when it was notified to the staff concerned, and not on the 20th of December 2017 endorsed on Exhibit as endorsed on Exhibit D3. It follows from the above holding and finding that Exhibit D3, which was notified on the 29th of December 2017 to all staff of the defendant after the cessation of the employment of the claimant on the 28th of December 2017, is not and cannot be made applicable to the claimant. This court finds that the policy manual of the defendant applicable to the claimant in is Exhibit C4, which was in existence as at the time of the cessation of the claimant's employment. These aside, the law is tried in the realm of labor relations that an employer cannot take away a benefit already accrued to an employee by amending staff handbook or condition of service in order to deprive an employee of such benefit already accrued. I find and I so hold. This honorable court is in total agreement with the learned claimant counsel on his legal submission, on the principle and concept of legitimate expectation, to the effect that the defendant cannot, by unilaterally amending the policy manual, deprive the claimant of a legitimate expectation interest. That is by amending the policy manual and soon terminating her employment to make her lose her entitlement under the earlier manual. No other inference can be made other than the conclusion that all were done to target the staff and cut down the liability of the employer legitimately expected and due to the staff in this case. See the decisions of my learned brothers in the cases below, which, though persuasive, are very apposite and germane. Mr. Patrick Obiora Modilim against UBA are reported. Suit number NICN LA 353/2012 delivered on the 19th of June 2014. Medical and Health Workers Union of Nigeria and others versus Federal Ministry of Health are reported. Suit number NICN/ABJ/238/2012 delivered on the 22nd of July 2013, and engineer Mrs. Mary Unobe Tembo and Shakasa Nigeria Company Limited are reported. Suit number NICN LA 250/2017. The judgment of which was delivered on the 28th of February 2020. Having held that Exhibit C4 is the applicable policy manual of the defendant in this case, it follows that the provision of redundancy entitlement as is enshrined in Exhibit C4 is the applicable entitlement to the claimant in this case. It is not in dispute between the parties that the claimant's position was declared redundant by the defendant. The evidence adduced is that the claimant's employment was permanently and involuntarily terminated by the defendant based on redundancy as evidenced in Exhibit C3, and that the claimant was on grade level of senior manager at the time of the termination. Clause 8.2 of the Dependent Human Capital Policies and Procedures HCP Manual 2013 with 2015 Amendment Exhibit C4, which was the extant policy manual as at the time the claimant's employment was terminated, having stipulated 12 months salary as guaranteed pay for an employee who has served 5 years and above. This code holds that the claimant has established her entitlement to relief one sought in this case, having been shown that the defendant only paid the claimant 6 months salary as gratuity pay. Or relief two, I have considered Exhibit C1 as well as Exhibit C4 on this issue. This honorable court has noted the testimony of the claimant that she was neither given 1 month notice nor 1 month salary in lieu of notice by the defendant, who has admitted this fact, but argued that 1 month salary in lieu of notice is consolidated into the redundancy guaranteed pay given to the claimant and not paid separately. I once again looked at the provision of Clause 8.2 of Exhibit C4 and noted that the provision only specified the criteria for calculating the amount due as guaranteed pay for redundancy and not the procedure to be followed in effecting the termination by redundancy. No wonder the defendant learned counsel later in his final address soft pedal and turn around to submit that the defendant conceded to this claim on the ground that it was not specifically stated as part of the guaranteed pay. This court is also quick to add that the provision of Labor Act is only applicable to a worker as defined in the Labor Act and not and of which category the claimant does not belong. In Exhibit C1, it is copiously stated that either party may terminate the employment by giving 1 month's notice or salary in lieu of notice. I therefore have no reason not to give effect to the express terms of the employment contract between the defendant and the claimant. This issue is also revoked in favor of the claimant accordingly. Relief 3 is for the cost of amortization of the claimant's car, and Relief 4 is for medical expenses, both of which evidence have not been laid in support. And for this reason, I find that these reliefs are not grantable and I so hold. This honorable court has keenly observed the Relief 5 of the claimants, which has double legs of pre-judgment and post-judgment interest. Relating to pre-judgment interest as claimed by the claimant, I have gone through the abandonment of the claimant as well as the evidence adduced before this honorable court, but I am reluctant to find any shred of evidence in support of this leg of the relief. The principle governing the claim for pre-judgment interest is that not only must it be claimed, but facts must be laid and proved on the ground justifying its grant. Pre-judgment interest can only be granted when provided by statute, express agreement between the parties, existence of mercantile custom or trade practice, or under the rule of equity like breach of fiduciary relationship. The cases of Kanyip Motors Limited versus UBA, Procon Group Africa Limited and Ayuba, MTN Communications Limited and C Soka, and other cases cited thereunder. The law is the law which has become immutable and sacrosanct is that claimants' right to interest in like any other issue in a case based on the evidence placed before the court. As such, a claimant who has no claim or evidence on the interest which he merely claims in the originating process without more had no claim or evidence before the court upon which the court would base a favorable decision for such claim and for such a claimant. There is no evidence of any statute or contractual agreement between the claimant and the defendant upon which this honorable court can base the claim. There is no evidence of any mercantile custom or trade or trade usage which is known to the parties. There is also no pleading and proof of any breach of fiduciary duty under which the court can invoke equitable consideration to grant prejudgment interest in this case. On the strength of this settled position of law, the claim for prejudgment interest of 21% per annum on the claimant on the claim sum from the 1st January 2018 until judgment is hereby refused. As regards post-judgment interest rate of 10% per annum until final liquidation of the judgment sum by Equinij and versus Wayne West Africa Limited, citation supplied, the Apex quoted that post-judgment interest may be awarded on the judgment date in a case, either as of right or pursuant to the provisions of statute. In the instant case, the rules of this court, more particularly Order 47, Rule 7 of the NIC and Civil Procedure Rules 2017, as well as the provision of Section 14 of the National Industrial Court Act 2006, empower this court to award for judgment interest of not more than 10% per annum, not less than 10% per annum to a successful party, the claimant in this case. Accordingly, I hereby exercise my discretion in this case in favor of the claimant and to grant the post-judgment interest at the rate of 10% per annum on the judgment sum until final liquidation of the entire on the entire sum granted. Coming to the claimants to the claim for cost of this action in Relief 6. This court is not oblivious of the fact that the claimant has indeed expended some amount of money in the prosecution of this case, just as the defendant has equally incurred expenses. The East Court has also taken cognizance of the Exhibit T10 Solicitor's Fee note tendered by the claimant. While the law is notorious and settled beyond peradventure that in the absence of clear and express agreement by the parties, legal fees or professional fees paid by a party cannot be claimed from the adverse party. See Emirates Airline versus Tochukwu Apoka. The Apex Court in the case of Union Bank of Nigeria PLC versus Opara, citation supplied, has adopted a liberal view to the solicitor's fee, which falls under special damages. Should not merely be pleaded, but must specifically be proved. And where proved, it should be granted. It is also settled that every shred of controversy that the purpose of the award of cost of action is not to punish the unsuccessful litigant, but to compensate the successful party for the expenses to which he has been put by having to come to court. See the case of Lage versus Akimbiyi and Lainka and another versus Makinde. Applying the above, the foregoing dilated principles of law to this case, I have conducted I have carefully examined the claimant's statement of facts and the totality of evidence adduced before me by the claimant, and noted that not only had the claimant pleaded these head of claim, but also laid evidence by the testimony of the claimant at paragraph 17 and 18 of the written statement on oath, where the claimant's witness testified as to the payment of solicitor's fee. Exhibit C10, which is the invoice/fee note, was tendered in evidence in proof of the claimant solicitor's fee. Moreover, Order 55, Rule 5 of the extant rules of this code empowered this court to grant claim for cost of action, including solicitor's fee, when proved. This court, however, finds and holds that this court therefore finds and holds that the claimant has satisfied the burden of proof imposed on her with respect to this relief, and as to this relief as to be entitled to same. This is an appropriate case, in my view, to grant such a claim. Accordingly, I award the sum of 750,000 naira against the defendant in favor of the claimant to as cost of this action. In sum, I find that the claimant case succeeds to the following extents. Relief A is hereby granted in its entirety. Relief 1 is granted in its entirety. Relief 2 is also granted by order of this court. Relief 3 and 4 are hereby refused. Relief 5 is granted to the extent of for judgment interest of 10% per annum until the final sum is liquidated. Relief 6, is for the sum of 750,000, which I have already granted. The adjudged sum shall be paid within 30 days from today, failing which it shall attract the said interest of 10% per annum until fully liquidated. What is the fate? What then is the fate of the counterclaim in this case? The defendant having abandoned and or withdrawn reliefs A, C, D, and E thereof and considered relief B, which has been granted in the main suit, the law is recondite that a counterclaim is distinct and separate action, independent of the main action in which it arose, and thus the failure, dismissal, striking out of the main suit does not affect the validity and subsistence of the counterclaim. It is said to be a cross action which has its own pleadings, judgment, and cost. See the case of Oroja and others versus Adeni, Ebona, and against Attorney General of Imo State. In this case, where the counterclaim has abandoned those reliefs, the law is tried that such claims abandoned by the counterclaim are no more live issues before the court, and such reliefs A, C, D, and E of the counterclaim are by order of this court dismissed. Dismissed.
As the court pleases.
Concession by the defendant to relief B, which has already been paid for and granted accordingly in the main suit, will serve no purpose in this instant case. The counterclaim pays accordingly, and the same is hereby dismissed.
As the court
Judgment is entered accordingly.
As the court pleases. My Lord, we commend my Lord for this brilliant judgment, sir.
As I said before, all the remaining remaining three judgments have something in common, particularly as regards to the
My Lord, we are grateful for the time given
You're welcome.
to this judgment. My Lord, we are
You're welcome. The second case is on the course list is suit number NICN/LA/230/2018 between Oluwaku Stella Adeseun and Keystone Bank Limited. Parties.
The claimant is absent, sir.
Representation of counsel.
May it please my Lord, Peter Olomola is my name, sir. I appear for the claimant. My learned friend, Abibat Bankole Akpina, appears with me, sir.
Yes.
may my Lord be pleased.
Yes.
Ameo Kolawole, appear for the defendant. I'm most obliged.
It seems like you are having issues with the network. Mrs. Kolawole.
My Lord, My lord, I'm
You said you're
Okolawole.
having issues. Okay.
I most humbly appear for the defendant.
Okay.
I'm most grateful, sir.
You're welcome. The judgment is ready. I will read the introduction, the reliefs, and I will skip the submissions of counsel to read the decision portion, particularly the areas where the case differs from the previous one.
As the court pleases.
Yes. By general form of complaint and other accompanying processes, the claimant approached this court on 11th day of April 2018, claim for the following reliefs against the defendants. One, the sum of 7,323,527 naira 50 kobo, being the outstanding redundancy entitlement in line with the item 8.2 of the Dependents Human Capital Policies and Procedure Manual 2017 as amended in 2015. Two, the sum of 1,220,587 naira 92 kobo, being the claimant's 1 month salary in lieu of notice. Three, the sum of 1,750,000 naira for 4 month car amortization allowance that was not paid to the claimant. Four, the sum of 268,233 naira unenjoyed 2017 annual leave allowance. Five, the sum of 59,923 naira expended on the concealed compliance course by the claimant. Six, the sum of 5 million naira as damages for unlawfully withholding the claimant's original title documents. Seven, interest rate in the sum under relief 1 to 6 above at the rate of 21% per annum from 1st of January 2018 until judgment, and thereafter at the rate of 10% per annum until the sum is fully liquidated. 8, a declaration that having fully paid the mortgage, the defendant is not entitled to retain the original title document of the claimant's property. 9, an order compelling the defendant to release forthwith the claimant's original title documents. 10, the sum of 750,000 naira being cost of action. Upon being served with the originating processes, the defendant entered appearance and filed a memorandum of appearance and the defense processes on the 28th of May 2018, and later amended the defense processes and counterclaim against the claimant as follows. I will skip the reliefs counterclaims as I have mentioned them already in the other case. The brief part of the case, the claimant was employed by the defendant and her employment was terminated on the 28th of December 2017 by notice of cessation of employment. But the sum paid to her as entitlement fell short of the amount due to her under the defendant's Human Capital Policies and Procedure 2013 as amended in 2015. that he was employed by the dependent on the 5th of August 2011 and was promoted in 2012 to the grade of senior manager, in which managerial capacity she served till the termination of her employment. Proof of her case, the claimant testified for herself as the claimant witness and tendered 13 documents which were admitted and marked as Exhibit C1 to C13 respectively. The case of the defendant is that the claimant is not entitled to the sums claim, that even the payment made to the claimant were made in error because under the Dependent's Human Capital Policy 2017, which was approved on the 20th of December 2017, a week before the claimant's employment was terminated, and thus applicable to the claimant is only entitled to 1 month's payment in lieu of salary and nothing more. That the dependent, under the terms and conditions of service between the parties, has the unreserved right to amend its human capital policy at any time, and that the claimant is bound thereby. So since redundancy does not exist under the human capital policy of the 2017, the payment made by the dependent for redundancy of the claimant to the claimant was made in error, and as such, the claimant is only entitled to 1 month's salary in lieu of notice. Now, the dependent is therefore entitled to refund the balance of the redundancy sum paid to the claimant after the deduction of the 1 month's salary in lieu of notice, which the claimant is entitled to from the sum paid. The dependent tendered through the dependent's witness 4 documents which were admitted and marked as exhibits D1 to D4 respectively. I've already said that issues relating to the preliminary objections and the position of the human capital policy and all other issues that are common have already been stated in the judgment just delivered in the other case. So I will skip them here and I will just go ahead to the reliefs, which are different from the ones in terms of the quantum and other issues. I will start with relief 3 also. Here is for the cost of amortization, which I said has failed in the other case. Here it also has failed in the absence of evidence. Relief 4 is for claim for the unused part of annual leave allowance for the 2017. This court has again holistically and comprehensively perused the terms of the condition of service as contained in Exhibit C1 and C4, particularly clause 1.0 of Exhibit C4, item 2.0 of Exhibit C4, 102 staff leave policy of the dependent, paragraph 3.3 of Exhibit C1. After a careful examination of the provisions on leave policy of the dependent as entrenched in Exhibit C1 and C4, the words which are very clear and unambiguous and which I will construe based on their ordinary and natural meaning by the authority of Abdul and Shekolo and Babalola and Apple Incorporation and Mamunu and another versus Dikat, citations of light. The claimant is entitled to 25 days annual leave, which can be used at any time within financial year, but not more than twice in a financial year. Any leave not utilized in a year cannot be deferred to the next financial year, but it is deemed forfeited. However, where the dependent has exercised its power to recall an employee from leave, the employee shall be paid an additional 50% of his current leave allowance whenever he is allowed to proceed on the remaining leave period for which he is entitled. In this instance, it is not in contention that the claimant's application for annual leave was approved, but the claimant could not enjoy the 18 days out of the 25 days simply because the dependent made the claimant to stay back for 4 days to attend to deposit mobilization. And when the claimant finally proceeded to utilize the remaining leave, she was recalled by the dependent. Exhibit C11 dated the 4th of December 2017 and C12 dated the 28th of December 2017 were put in evidence to buttress this. In all, the claimant was only able to enjoy 7 days out of the 25 days. However, the defendant had argued that Exhibit C11 and C12 stated by the claimant do not establish that the claimant is entitled to utilize leave allowance, to unutilized leave allowance. The learned counsel to the defendant had argued that Exhibit C1/D1, C4, and D3 do not entitle the claimant to claim leave allowance for annual leave days beyond the financial year. That the approval granted in Exhibit C11 by the defendant was wrong as it ran counter to the defendant's policy against the deferment of annual leave till next financial year. Thus, the reason for the recall in order that's the reason for the recall in order to avert the error of illegality. In the circumstance of this case, will it be just and fair to approve this line of argument by the defendant? First, the defendant did not dispute that it occasioned the 4 days initial deprivation. Second, the defendant did not dispute that it occasioned the 14 days left thereafter the use of the 7 days. Third, the defendant did not dispute that it recalled the claimant but did that not to allow the unused leave to cross over to the next financial year. And as such, since the claimant did not utilize this remaining leave within the year 2017 and cannot be deferred to the next financial year, the claimant has forfeited it and not entitled to the additional 50% of her current leave allowance as well. So the claimant should bear and suffer the burden of the actions or omissions of the dependent. Fourth, sooner the claimant was recalled, she was served with Exhibit C2 dated the 28th of December, notice of cessation of employment. All these established facts point to one and only one conclusion, that the defendant deliberately intended and indeed technically deprived the claimant of her entitlement to the remaining leave allowance and turn around to take shield and cover under the canopy of policy manual. This indeed is nothing short of unfair labor practice, which is called by the dictate of the provisions of the Constitution and the act establishing it is empowered to nullify and nullify and deprecate in strong and firm terms by virtue of the international best practice and labor standard. However, this code is not Father Christmas. It's not a Father Christmas. The court decides matters before it based on the evidence adduced by parties. Courts are not allowed to separate or engage, to speculate or engage on wild goose chase of facts not presented and laid bare at its doorstep. The claimant thus shouldered the duty not only to establish that he was unfairly deprived of the leave allowance in this case, but also to present the amount of the leave allowance he is entitled to by credible evidence and not just explicit. The claimant has claimed that he is entitled to 18 days unenjoyed leave allowance, which he summed up to 268,000 naira. I have tried to ascertain how the claimant arrived at this quantum, at least at what, to know the total amount payable. I mean, at this quantum, but I could not. I could not lay my hand on any. In the absence of evidence, I find that this relief is not grantable and I so halt. Reliefs 5, 6, and 8, relief 5, 6, 8, and 9 are with respect to the claimant's mortgage, title document, and the cancelled cause allowance, which the claimant has abundantly admitted in the course of trial that the defendant has handed over the title document to him, as well as paid the cancelled cause allowance to him. This Honorable Court agrees with the defendant counsel that these aids of claim have become spent and overtaken by events. It will amount to mere academic exercise with no utility value for this Honorable Court to dwell on the said reliefs. The said reliefs are hereby struck out having become spent, overtaken by event, redundant, and no more live issues. See the cases of NASCO and another Fellow, EcoBank and Honeywell Flour Mills, Nigerian Ajib Company Limited versus Nwopuru, and another, and Adegun versus Pashobon Citation Supply. I have observed relief 7, which is for pre and post judgment interest for the reasons given in the earlier decision for the reason given in the earlier decision just delivered. I don't need to pronounce on this again as it supports the same page. Pre-judgment interest is refused, while post-judgment interest of 10% is awarded in respect of relief 7. So also with the claim for the cost of action, which is relief 8, which I granted the sum of 700,000 naira, 750,000. In totality, the claimant's case succeeds on the following terms. Relief 1 is, in terms of relief 1, reliefs 1, 2, 7 to the extent of post-judgment interest, and 8. Like the other case, the counterclaim is also dismissed. In sum, for all the reasons I have given, the counterclaim has been dismissed. Judgment is entered accordingly.
As the court pleases.
As the court pleases. My Lord, we are indeed very grateful for the time devoted to the judgment.
The next case is Olabode Stephen Osho versus Keystone Bank Limited with suit number NICN/LA/231/2018. Parties are absent. Representation of counsel.
As the complice, with utmost humility, my lord, my name is Peter Olomola. I appear for the claimant.
May my Lord be pleased.
Yes.
I'm Adenike Kolawole. I most humbly appear for the defendant. I'm most
Okay.
obliged.
Okay. It goes this way. I will read the introduction, the reliefs, and I will skip the submissions. Even the reliefs are, anyway, by general form of complaint, statement of parts, and other front-loaded documents. The claimant instituted this action on the 11th day of April 2018 and claimed for the following reliefs against the defendant. One, the sum of 6,195,771 naira, 36 kobo, being the outstanding redundancy entitlement in line with item 8.2 of the Dependents Human Capital Policies and Procedure Manual 2013, amended in 2015. B, the sum of 1,032,000 being the claimant's 1 month salary in lieu of notice. C, interest in the sum of over the said sum from relief 1 and 2 at the rate of 21% per annum from 1st of January 2018 till judgment, and thereafter at the rate of 10% per annum till liquidation. D, 750,000 naira as cost of the action. Upon being served with the originating processes, the defendant entered appearance and filed defense processes on the 28th of May 2018, which it later amended and counterclaimed against the defendant for the refund of the sum of 6,195,771 naira. It paid in error into the claimant's account as redundancy benefits and salary in lieu of notice under the Human Capital Policies and Procedure of 2017. B, a declaration that the claimant is entitled to the sum of 1,032,000 naira, 32,628 naira 56 kobo being 1 month salary in lieu of notice under the claimant terms of employment. C, an order setting up the sum of 1 million being 1 month, 1,032,628 naira 56 kobo being 1 month salary in lieu of notice against the defendants. 6,195,771 naira 36 kobo paid in error into the claimant's account as redundancy benefit, and an order directing the claimant to refund and credit the defendant immediately with the balance in the sum of 5,163,142 naira 80 kobo. E, an order for cost of the action. The facts of this case is entirely the same as the two cases over which I just delivered the judgment. And I think I don't need to repeat it here. I'll just keep and move to the decision portion. I only need to add that the claimant improved of his case as tendered 10 documents, while the defendant tendered 4 documents. Now move to the decision portion. Even at that, I will start with the reliefs. And the reliefs are also almost similar with the other ones, except for the difference in the quantum of the amount being claimed. In totality, the action of the claimant succeeds to the following extent. Relief A is granted in its entirety. Relief B is granted by the order of this honorable court also. Relief C is granted only to the extent of post-judgment interest of 10% per annum, commencing from the 30 days within the delivery, after the delivery, after the delivery of this judgment. Relief D is also granted to the tune of 750,000 naira at the cost of this action. The counterclaim having failed is dismissed as in the other cases. Judgment is entered accordingly.
My Lord, we are most grateful for this well decided.
My Lord, we are equally grateful for the effort my Lord devoted to the judgment.
All the issues are similar except with difference of some reliefs and the contour. So there is no point repeating. We better save our time.
As the court pleases.
As the court pleases.
The last case is the last case. The last case on the course list is suit number NICN/LA/232/2018 between Omubo Iyerepaka and Keystone Bank Limited. Parties.
Claimant absent, sir.
Representation of counsel.
With utmost humility, my Lord, my name is Peter Olomala. I appear for the claimant, sir.
May my Lord be pleased.
Yes.
I most humbly appear for the defendant.
Okay.
I must oblige, sir.
Okay. Judgment is ready. Here also we have 5 reliefs. The claimant commenced the suit on April 11th, 2018 against the defendant and prayed for 5 reliefs, which are stated in the face of the judgment. The defendant, in reaction, entered appearance on the 9th of May 2018 and filed its defense processes on the 28th of May 2018, which it later amended by the order of this court granted on the 29th of October 2018, where it counterclaimed against the defendant for 5 reliefs. Against the claimant for 5 reliefs. The parts of the case are entirely the same as the one as the last 3 I delivered. I think I need not to repeat it here. I only need to point out that the claimant, in proof of his case, has tendered 10 documents which were admitted and marked as exhibits C1 to C10 respectively, while the defendant tendered 4 exhibits which were admitted and marked as exhibits D1 to D4 respectively. Turning to the decision portion, for the reasons I gave earlier, that the cases share certain things in common, and I used this opportunity to read the first one from the beginning of the decision portion to the end. I think I only need to point out that in totality, the action of the claimant succeeds to a certain extent in terms of relief A, C, D to the extent of a respect of post-judgment interest of 10%, and E to the tune of 750,000 naira granted as cost.
Okay.
With regards to the counterclaim, for the reasons stated in the last case, the counterclaim fails and has been dismissed, and judgment is entered accordingly.
As the court pleases.
My Lord, we are most grateful for my Lord's time, both yesterday and today. And we wish my Lord continued good health. We are grateful, sir.
Thank you. You're welcome.
My Lord, we are equally grateful for your Lordship's efforts and diligence.
Thank you.
We pray God to grant my Lord good health.
Thank you. I wish same for all of you.
Thank you, my Lord.
Grateful, sir.
Rise. Bye-bye.